right, guys, welcome back to another Justice News Break. And we are here, guys, talking about a case that's going to be coming up for trial next year. We finally have a trial date. I think it's a pretty set in stone date as well. It's a case I know I've been following. I'm sure you have too. And it is the case of the OnlyFans model unaliving trial, Courtney Clenney. You see it right here. We're going to talk about the article here. 3 years, no trial. She had a very significant uh, pretrial hearing that just happened right before Christmas. We're going to get into that. There's a link in this article. Go over to justiceasaprocess.com. That's www.justiceasaprocess.com. We will also be including a link to the website in this description and to this article in this description. So you can go over, read the article, check out our coverage, and check out the hearing itself, which we covered as well on the channel. So without further ado, let's jump in and check out this article and get things started. All right, everybody. So here we are. Like I mentioned, this is the Courtney Clenney case. She's been incarcerated now for 3 years. She's not out of trial, and she was recently denied bond again. We're going to get into what happened in this hearing. So um, let's talk about this. So she went to court recently, and she filed a motion. There were two things being argued at this hearing. One, for asking for bond. It was basically a assessment of her Arthur hearing. They were claiming that there's new evidence in place that would allow this case to potentially be considered a manslaughter case, which is a significant development, very significant development. And on top of that, they also had a situation where they had discovered that potential exculpatory evidence was destroyed, and they were asking for a dismissal under the Youngblood case, which I'm very familiar with, and many of you should be familiar with both of these arguments. It's happening in Florida from the very early coverage we did on this channel of the Ty Tucker case. It almost sounds exactly very similar to the things that were done. The prosecutors also, and one of the arguments here is there was the original prosecutors were so corrupt they had to be thrown off the case. They had violated attorney-client privilege. They had looked at emails that they got their hands on and looked at them, even knowing that they were looking at potentially uh, protected information. They did it anyways, and they got themselves tossed off the case. Anyways, we're getting all of that here. So this, as I say in the article, this was not a please have mercy motion. There was some issues here that were being discussed that had some teeth. So first, we heard uh, well, we didn't hear from him, but there was a new forensic expert that the defense had used, and they had analyzed the blood loss from Christian Obincelli's subclavian artery injury, and they calculated backwards that when this incident occurred, that the injury had happened within seconds or a minute of the 911 call. This is significant because at the hearing, when they denied her bond, the allegation to get to second degree unaliving was that she had waited almost 13 to 14 minutes prior to calling 911. That's where they got the depraved mind, the depraved that they needed to prove. And they claimed, now the defense said with this new expert testimony, that falls apart. And that now what we're dealing with here is a manslaughter case. Because remember, what's described on the 911 call, what's always been the allegation of Courtney Clenney to investigators that she gave when she gave her police statements, and that was that the incident happened that she threw the knife and it accidentally stabbed him. But it was known that this came out of an argument, that they were arguing when this happened, that this was a moment that was done in the heat of passion, in the heat of the moment, which very much can be covered by a manslaughter charge. Manslaughter is a bailable offense. That's why they came into this hearing saying they wanted bond. On top of that, there were delays in the case that were not the reason why this case hasn't gone to trial. There were delays that were not at the defense's fault. They were the fault because of the prosecutors who essentially violated attorney-client privilege, thereby discovery couldn't happen because these were tainted prosecutors. And the defense said, listen, we had to deal with this issue. and our client had to sit in jail. Now, um, the other bombshell that drops in this hearing is that there was a building employee by the name of David Delbay, and he testifies in a civil deposition, which is in the record, that he entered Clenney's apartment before police arrived, found her clutching Obaselli's body, begging for help, and he took photos and videos of the scene. Now, that means this individual is on the scene before the police are on the scene. There's observations, there's things, there's evidence, there's things that are in place, and all that's very, very important because, again, the prosecutors are claiming that she did not render assistance, that she didn't render help, that she essentially let him bleed out, and that she wanted him to die, right? So this completely contradicts that. In fact, this supports the idea that this was the product of a moment where things went awry, and she ends up stabbing him and then calls for help immediately. And then he ends up dying, not because she delayed calling for help, but because of a reckless act that was done in the heat of passion, meaning, i.e., manslaughter. Once again, now the other thing that happens is the state had known about this gentleman. They had surveillance footage, have had it from the beginning, but it gets worse because when he arrived and the police arrived and they realized this gentleman was documenting the scene and taking pictures, instead of collecting those pictures as evidence, they forced him to delete all of the pictures that he took. Only one picture remained that survived because it was later scraped off social media because he was able to, I guess, recover this picture. Um, and, you know, we have a situation now where the police disregarded potentially exculpatory evidence in this case, knew that this gentleman was in existence, knew what he had witnessed, never bothered to interview him, never bothered to ask him what he saw, um, and, you know, essentially deprived the defense of this information. The defense asked, of course, that this is what you call a Brady violation. This is exculpatory evidence that was kept from the defense for years, and the ask that the defense gets to ask the judge is the remedy of this is dismiss the case. The judge opted not to do that, obviously. There's a third bombshell that hit, and it was that the prosecution had been arguing from the beginning that Clenney was a flight risk because she had millions of dollars in the bank. Her defense comes to court and shows that she no longer has any financial means. Her home is in foreclosure. Her bank account was overdrafted by $310.26, which the bank had wrote off as a financial hardship loss, and that she's pretty much out of money. But the judge denied all the motions, denied the bond motion, denied said that yes, um, the evidence destruction, one of the factors that must be shown in order for this to, and this is why it's such a hard bridge to cross to get a judge to dismiss a case over Brady violations, has to be shown in bad faith. It has to be shown that that was done with ill intent. And they said, no, that was a bad decision, but it wasn't done in bad faith. And the prosecution was overlooked. These are new prosecutors, and the judge basically said, we're not going to dismiss. On top of that, they said that the forensic evidence and the financial collapse was not a material change in circumstances, meaning it doesn't change anything that was already in place before. That she's charged with second degree. She's, there's a potential that she has money hidden somewhere because it was pointed out by prosecutors that there was $1 million transferred from her bank account to her parents. Um, but what the judge did say is that she is going to keep Courtney Clenney locked up. She's not going to give a bond, but that she is going to make sure and she is going to demand that a hard and fast trial date of April 27th, 2026. Put it on your calendars, everybody. April 27th, 2026 is when this case is finally going to go to trial. And we will be there covering on Justice as a Process. You better believe it, because this is going to be a fun case to cover because there's going to be a lot there, as you can already see. This is going to be one of those deals where, the presumption of innocence is going to be a big deal here, because one of the things, once if she can show, and especially if she alleges this was self-defense, which I believe she might be what she's claiming. I don't know. We haven't seen the full throated defense here, but there's going to be an element here to saying, hey, look, the state has to prove beyond a reasonable doubt that she did this with a depraved mind, that she did this with the intent to kill him, and to get the top charge. You can already see the defense is looking and angling for a manslaughter charge here. And since there was no firearm, understand that means it's a 15-year sentence. So substantially less sentence than in than a uh, than a second degree unaliving conviction, and we'll see what happens. Here is the link. We're not going to watch the hearing, but here's a link to the hearing. You come over here, you click on that, it'll take you right there, and then come down here and join the discussion. I would invite all of you to make it known. What do you think about this case? What do you think about the judge's ruling? Do you think 3 years is too long to be holding someone, especially when you've got the change in circumstances? Do you believe the forensic evidence and the evidence that suggests that he bled out within a minute, and that he was not sitting there for 14, 15 minutes prior to the 911 call? Does that change everything? Should that have changed everything? Does the financial evidence change anything? Does the fact that the state ignored exculpatory evidence change anything? Let us know. So, guys, look, that's where we're going to end the discussion. I would invite you to go over and check out this article. Lots more details in the article. Check out this hearing for yourself. Watch the hearing. See what you think. Tell us what you think. Do you think this is fair? Did the judge make a fair ruling? And give us your thoughts on the case. Do you think this is going to be an open and shut slam dunk case? Or do you think the defense is going to have a case to make here, depending on how this plays out and what this happens? Like I said, I do believe they're going to be claiming, from my understanding, there's going to be some form of a self-defense claim here. But we'll see. We'll see where the defense goes with it. Could there be a plea bargain come up? Maybe. I don't know. I think that'll be an interesting situation to see if that develops, how this goes as we get nearer to the trial. A lot of things happen sometimes when that trial date approaches. She's already been in for 3 years. So there could be an attractive plea on the table that could say, hey, listen, you only serve you'd only need to serve so many more years and you're out. She's already done 3. She's not out on bond. It makes a plea bargain that much easier. We'll see what happens. What happened in the Tyrone Tucker case? They gave him a plea before he went to trial, but we'll see. Of course, he had to try it the first time and get a mistrial, but we'll see. Anyways, in the meantime, guys, head over there to justiceistheprocess.com. Check out all the case coverage that we're giving you right now. We're finishing up and finishing the record on the Uriah Urick case, a case that we covered back in November. We didn't get a chance to put the full podcast out. We're doing that now over the Christmas holiday, and we are finishing that record, and we are putting it out for you. So jump out over there. We're doing the full coverage. We're generating the justice breakdowns. We're doing desk posts on it. Go over, check it out. It's a very interesting case that happened out of Texas, and it will shock you that this is what happened, that 2 young kids did what they did in this case and did it for so little. But that's what again, check it out. In the meantime, guys, we'll be talking to you soon. Until then, let justice prevail, and we will talk to you soon.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people Unite.